Okay, this is legal reform. Okay, I put a lot of laws on here. One I want to discuss majorly with you is funny term. The major thing I want to discuss with you is the color of law. Okay, and living under the color of law. Basically meaning there are a lot of laws out there that should be non-existent simply because they violate the very principles the Constitution was founded on. Okay, so there's a lot of laws that shouldn't exist, a lot of things that are happening that shouldn't be happening, a lot of things that should be happening that aren't happening, which is basically living under the color of law. These are not opinion posts, these are just legal sites to help you find resolution. The only justice reform you need to learn is the rules of professional conduct, the code of judicial conduct to obtain due process. So I'm just going to go over a few of the posts: legal reform, legal resources for making a change in the legal system. Public trust doctrine. Should look that up. The public trust doctrine is very important in every democracy, and it's mandatory in every democracy for every politician, every lawmaker to do what's in the public interest to maintain the public trust. That's also in the preamble of the rules of professional conduct. Okay, the public trust doctrine includes the water, the air, the land, the airwaves. In the public trust doctrine is also the legal system, healthcare system. Is just that you're so used to it operating on a manner that's insufficient and ineffective manner and does not abide by the oath of public service. So you violate the oath of public service, the oath of office. Penalties are fines, removal from public service, and incarceration. But
if you've ever disrespected me, and
see
I
some of the videos I made. It's on TikTok. Okay. Something you should be contemplating. Project 2025 back in 1933. Okay, I mentioned here Government Code 1386. Okay. Every person, while taking and subscribing to the oath of affirmation required by this chapter, states as true any material matter which he or she knows to be false, to be guilty of perjury, and is punishable by imprisonment, state prison for 2, 3, or 4 years. So these posts, you got to go through all of them and piece together the ones that you need. You may not need all of them, but you're going to need quite a few of them. Okay. Let's see, the penalty for deprivation under the color of law. Okay. So here I put, this is just a short story of living under the color of law. My other posts point out a whole lot of other things that aren't being done. I use these very things for myself and many others to seize the day. I can't be there for everyone, so I need you to have your 6 like I had mine. Nobody taught me this. I had to learn on my own. I need you to have your 6 like I had mine. Lots of ammo at your disposal at legal reform. The only thing you need to spend here is time. I'm just showing you the laws. It's up to you to use them. The law affects you in every way. I got to redo that. Correct that. In every way, think in the public interest. You could look that up on the net. And maintain the public trust. Look up the public trust doctrine. Okay? 2 important laws in every democracy. Every law must be in the public interest, and the judicial system is part of the public trust and the use of the law to make it happen. Okay? I've been trying most of my life, but I can't do it alone. Plus, I'm getting old. The torch needs to be passed. Take advantage of what I had to dig and fight for: knowledge. I had a Dewey Decimal System, but now you have me and everything I ever read on the internet. So that's what's stopping you, okay? So what are the penalties for deprivation rights under the law? And I went through that legal on the internet with some legal sites. I put here, I take the law very seriously as far as that video goes. Over here, knowing the rules of professional conduct and the code of judicial conduct exists. Or not knowing the rules of professional conduct, code of judicial conduct exists. Big mistake, okay? But that happens because you're not a member of the legal, learned, professional community. Not caring the rules and codes exist. That's just, I've been preaching about it since 1979. It's time for all of you to get on this too, okay? These are the legal obligations of every judge and lawyer in a court of law. And since they don't do that, you have an easy win.
There's always been a lot of debate
Effective assistance of counsel
about attorneys and what their duties are.
See, so I mentioned that. All laws repugnant to the Constitution are null and void. I did a video just reading that to you. Okay, the reason I'm doing this because I have a dream, okay? If you remember Martin Luther King's speech, I have a dream. Well, my dream is the same as his. Our country will live up to our creed. Okay, so this isn't happening. Due process isn't happening because you don't have a fair trial, and you never got a fair trial because effective assistance of counsel didn't exist, doesn't exist, and won't exist until you go in there and demand it, okay? I've been doing my best.
I make folks nervous, man. I get folks moving in their seat. I get folks twirling their thumbs. I get them thinking and second guessing themselves. You know what? Have you ever been so clean that you walked in and somebody looked down at you, then they looked at themselves?
And also, if you read the rules of professional conduct in the preamble, it says cannot make laws that are in the interest of the bar or parochial interest. And parochial interests are, a religious doctrine. And they did that to garnish votes, which in the Code of Judicial Conduct, it says that all judges and any entities within the court are to remain apolitical. So that means they don't take sides as far as politics goes. So that move, overturning Roe versus Wade, was a political interest. It was a parochial interest, and it was an interest to the bar because they made money off of it. Okay, so I if you go through all these, you can put that together. Here's some posts I made in the public interest: maintain the public trust, legal obligations of all public servants. Okay, Illinois Attorney General launches unit to investigate wrongful convictions. Cook County State's Attorney Kim Fox was doing that, and she was basically doing her job. Rule 3.8 in the rules of professional conduct, special responsibilities of the prosecutor. And if you go towards the end of it, it says, it specifically says that, if you were to give the state's attorney exculpatory evidence, it's their job to exonerate you, to take it back to the court that it was in and exonerate you, overturn that judgment. So he's going to give the state's attorney's office a hand. The Department of Justice, Civil Rights Division, I wrote them, so they're supposed to be giving a hand. That's probably why the Supreme Court got pissed off and turned down that they had a case overturning, exonerating a case based on exculpatory evidence. They shot it down. Maybe they just should have said, hey, that's the state's attorney's job. There's so many people that are supposed to be doing this, but nobody's doing it. And then you wind up having to pay a lawyer to do it, and he won't do it because why? He's not effective assistance of counsel. Go over the rules of professional conduct with them. If they won't talk to you about it, they won't sit down and discuss it about it, you do not have a good attorney. Okay? And that's deprivation rights under the color of law. Every lawyer, every judge took an oath to the Constitution, and the Sixth Amendment of that Constitution guarantees everybody will abide by the rules of professional conduct and the Code of Judicial Conduct.
A motion to quash is to nullify decision made by the same or lower court. Try using that. Look it up. It's on the net.
Okay. So I go on about motion to quash. First black mayor of Alabama town claims he got locked out of City Hall. The people there said they didn't want to let him be mayor because, they weren't ready. And, wow. that shouldn't be happening. Where was Okay, I had arguments about politics with people, so this is where I came. Politically religious have called me a rhino or a dino, the lack of understanding of apolitical, abiding by the law, and doing what's in the public interest. Okay, prison reform, a lot of complaints about prison reform. Okay, but there's the Inmate Bill of Rights. That's not happening. Nobody's doing that. Okay, so many complaints about prison reform. I understand the lack of humane treatment pushes one to act out and become what they would never be because of said treatment. Treat someone like a feral animal, they become that feral animal. Unsure how many people know this, so I'm posting it. It's the start of enforcing prison reform. There's a lot of things in prison that shouldn't be happening that are happening, and the things that should be happening that aren't happening. So look up the Inmate Bill of Rights, okay, and that'll be a great help, people. Okay, the color of law, here it is again. Women's own right to abortion. Okay, me, every time a public servant asks me who the heck you think you are, I say we the people. This is pretty much the reaction I get. If they stick around long enough, I remind them the oath they took, and violating the oath is punishable by fines, removal from public service, and incarceration. When you know, you know. Say it to lawyers, a judge, a whole lot of them, cops, a few in the military, doctors, DOJ, the FBI. The list of public servants is huge, bigly. Look it up, it's on the net. Also posted it on legal reform. Violating the oath of public service is quite literally violating the law. The oath is unconditional. I posted that as well. Don't forget to use the letter of the law so there's no misinterpretation. Got to do that word for word to the letter. That's unconditional as well. Every time I bring up this stuff, this is what happens. This is what lawyers do. Whoa. They just... All right, asking the right questions is important. I usually ask the question. I just type it in a search bar. A lot of questions people ask on the net, I just copy and paste it into the search bar, and that's where I get the answers. Okay, AI is pretty active, so use it until somebody trains AI to deceive you. Right now, AI isn't. They just give you every answer possible to the question you might be asking. Sometimes you got to ask the same question repeatedly, but in different ways to get the right answer. Okay, so that's what I explain here. Okay, the easiest way to get ineffective counsel is to move forward is by citing prosecutorial misconduct and judicial misconduct. They work in conjunction. Okay, one cannot violate the rules of professional conduct without it being allowed. Okay, the judge is supposed to force them, the lawyers, state's attorneys, criminal court, civil court. It doesn't matter what court you're in. The rules of professional conduct, the code of judicial conduct are the common denominator in every court. So that makes them universal. Whether you're in probate court, in conservatorship, child custody, it doesn't matter. The rules and the codes are the common denominator. Okay, they have to exist in every court. If they don't, then you've been denied due process. Okay, so I explain that here. Okay, it's pretty well written out. It's kind of synopsis of my iteration of due process. Okay, more about the Sixth Amendment. I mentioned the Magna Carta. The Magna Carta says right here.
This is where you'll find that qualified immunity cannot exist.
Established the principle that everyone is subject to the law, even the king, and guarantees the right of individuals, the right to justice, and the right to a fair trial. Okay, so that clearly shows you that qualified immunity cannot exist because the rule of law was established to quash qualified immunity. Okay, so qualified immunity shouldn't exist. It's contrary to the rule of law. That's one of the main purposes I bring up the color of law, or living under the color of law. Okay, Another avenue to take claim. Here's where I talking about a letter to the U.S. Department of Justice. This was forwarded to them by FBI. Okay, so I've been making this very public, but it's not getting to them. They're ignoring every complaint I have ever made. It's rare that I ever get an answer. I did get an answer, though, from the FBI, and I just showed you that, and they forwarded it to DOJ, and I've been waiting since the early 90s for them to overturn these wrongful convictions, to stop this malicious prosecution. Every time I mention it, though, I think they find it upsetting, is that I mention what they took from me, they took from we, and I came there to get it all back. And actually, I mentioned it at the wrong time and wasn't able to get it on the record. My lawyer ran and told the judge that I was going to go out there and bring up the rules, the codes. It's mandatory to report misconduct in both the rules of professional conduct and the code of judicial conduct. I was in lockup. He ran out, told the judge, and shortly after I was taken into Cook County from lockup, down the elevator, through the Tombs, to Cook County Jail, and I was beaten and left for dead. And there's a video of that in here, going over the hospital reports. Violating your oath is a federal crime. Okay. Judicial reports of misconduct by judges must be made.
When people ask me how I know what I know,
so I teach people how to find it. Okay. I put here, please forward to Attorney General. Nobody's doing that. See. And here's where I talk about what happened to me, where I got my skull caved in. They tried to break every bone in my body, popped my eardrum, thought my head blew up. Okay, violating the oath of public service again. Okay, this guy, he was on Zoom, and he told the judge to cite his lawyer for ineffective assistance of counsel, the judge for prosecutorial misconduct, told the lawyers to cite the judge. Everybody's supposed to cite each other for a violation of the codes and rules, and they ignored him. They did throw the case out. They had him come into court after that Zoom meeting, but if you watch that video, you could hear him clearly state that his right to effective assistance of counsel, fair trial, due process, all null and void. But they let him go, but, you know, the time involved, mental anguish, the pain and suffering he had to go through because an illegal maneuver by the court, by the judge, the state's attorney, and the public defender's office to deprive him of his rights. Federal law can be defined as any formal code, rule, regulation, or principle. Okay, the letter of law can be defined as any political code, rule, regulation, or principle that must be followed according to governmental mandates or policy. In short, it is the law as it is written. But you won't get that from lawyers and judges. You know, I've seen some Supreme Court justice explaining what the Constitution meant. You know, when I read the Constitution, I use the letter of the law. The letter of the law was specifically written so we all hear, say, and see the same thing. So that way there can be no misinterpretation. That's why it's always important to use the letter of the law. Look it up, and it strongly suggests that it always be used. Anything devoid of the letter of the law is disinformation, and that's illegal.
Effective assistance of counsel is guaranteed in the Sixth Amendment of the U.S. Constitution. Any violation of the rules of professional conduct is ineffective assistance of counsel.
Okay, so let's see. Color of law refers. See, it says right here. The color of law refers to the appearance of legal authority or apparently legal right that may not exist. The term is often used to describe abuse of power under the guise of state authority and therefore illegal. Okay, so I'm just giving you a lot of stuff to, everybody got a story to tell. I'm just giving you a lot of laws to use that's just not happening. Nobody's doing it. No, when it comes to many of our public servants, a lot of them don't want to work. They don't want to do their job. And this is what you use to get them to do their job. There's a lot of stuff here, okay? Okay, on what grounds can a Supreme Court justice be impeached? Article 2, Section 4 of the U.S. Constitution defines the grounds of the impeachment and conviction as treason, bribery, or other high crimes and misdemeanors. But the Supreme Court, they may be, they got qualified immunity from the Code of Judicial Conduct. But the only reason that happened is because nobody abides by the rules in the codes. So that way you can kick it into appellate court. They won't see it through. So you'll kick it into the state Supreme Court and they'll say, no, F you too, because we do not abide by them either. And by the time you kick it up to the state or the U.S. Supreme Court, they say, hey, we don't have codes and rules. And when they interpret the law, it's always to void the letter of the law. So it's really ridiculous. But they are not. They are still, you can still hold them liable for violating the oath of public service, the oath they took as judges, and that's to the Constitution, which they did. And in that Constitution is the Sixth Amendment, which says every lawyer and judge must abide by the rules and the codes of professional conduct, and is their legal responsibility to report any said violations. Okay, so when you put this stuff together, you'll find even though the Supreme Court wasn't issued a code of judicial conduct, it was still codified in law that they must do what's in the public interest and maintain the public trust, and the judicial system is part of the public trust. Okay. Public service is a resource offered by an organization. So you want to look at what are public services definition. 23 examples. That's a short list, but basically anybody that gets a paycheck through taxpayer funds, taxpayer dollars are part of the public trust, and those taxpayer dollars are to be used what's in the public interest and to maintain the public trust, which forbids them from giving any of those tax dollars in corporate interests. Okay, subsidies, tax breaks. No, that's not supposed to be happening. Okay, I put here rooted in Roman in the public trust doctrine, recognize a public right to many natural resources, including the air, running water, the sea, and the shores. The doctrine requires sovereign and state to hold a trust doctrine resources, the benefit of the people. The public doctrine is actually a federal law that a lot of states excluded from their constitution. Here it says, and they can't because the state constitution has to be in line with the U.S. Constitution. If not, it is repugnant and considered null and void. Okay, so even if they didn't put it in, they have to put it in because it has to align with the U.S. Constitution. The U.S. Constitution is the law of the land. It's king of laws. Okay, judge sides with activists, first of its kind, climate change trial. And all they did was use the law, the public trust doctrine. They said, hey, you're supposed to do this and you're not doing. And the judge said, oh, my bad, we're going to do it now. But see, that's a key principle in democracy since forever, And if you ever research the history of democracy, you have to go way back to Greece. So ask a Greek. I just had to stop there. And then I posted about this. I got this from Department of Justice, Basic Obligations of Public Service. Okay, and actually I didn't know it was there. I was looking for it because I read about Thomas Jefferson when I was studying the Declaration of Independence and the Constitution. And that's when I came across the Magna Carta and quite a few other things. Thomas Jefferson enunciated basic principles of public service. When a man assumes a public trust, he should consider himself a public property. This sentiment has been expressed by numerous others, and over time becoming a familiar principle of public service is a public trust. Okay, so every public servant, you have no, you can't hide your taxes. Your life is an open book when you're in public service. You are a public entity, okay? To ensure public confidence and integrity of the federal government, Executive Order 12674 is amended. Okay, but you're going to have to, this is really interesting. It's long. Okay, I don't want to take up too much of your time. I posted some short videos on it. Okay, violating the oath again. So I keep reminding people that, reminding them the rule of professional conduct. Let's talk about the public interest and how it's not enforced. And so I talk about Roe versus Wade being overturned, and that's in the medical health. Okay, so that was in the public service until politicians and lawyers, sold off part of what's your trust fund, and they privatized it, which was totally illegal. But you just don't know. You're just used to it always being that way. But if you read the public trust doctrine, you'll understand. So, what you're going through, you shouldn't be going through. So, okay. Oh, so look at Rule 3.0, 3.8, Special Rules of Prosecutor. So I put one of those prosecutors, Nancy Aducci, heads Kim Foxx's Conviction Integrity Unit, which is tasked with identifying wrongful convictions. Okay, so like I said, Rule 3.8, you go down to the bottom. When a prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of offense the defendant did not commit, the prosecutor shall seek to remedy that conviction. Okay, well, this is more of that. Okay, so, Rule 3.8, a lot of states remove that. It's illegal. That was in the interest of the bar. It's preventing you from, it's keeping the full context of your constitutional rights from you. So you're going to have to bring that up. It's in the American Bar Association Model Rules of Professional Conduct, which every state's supposed to use. But like I said, some states took it out because they don't like to admit they did wrong. If two or more persons conspire to injure, oppress, threaten, or intimidate a person, state, territory, commonwealth, possession, district, or free exercise and enjoyment of any right, privilege secured to him by the Constitution, law, United States, or become or having so exercised same, or if two or more persons in disguise on the highway with intent to hinder free exercise and enjoyment of any right, privilege, they shall be fined under this title, imprisoned not more than 10 years, or both, or to death, or if a death results from the acts committed in violation of this section. Such are include kidnapping or an attempt to kidnap, aggravated sexual assault, abuse. All right, so you're going to have to get into that. But basically, you can use that because, it says right here, if two or more persons conspire to injure, oppress, threaten, intimidate any person in any state, territory, commonwealth, possession, or district, in the free exercise and enjoyment of any right or privilege secured to him by the Constitution, law of the United States, or because of having so exercised the same, or. Now, they'll tell you, no, we only use that against criminals, but they are criminals. They conspired to deprive you of due process, a fair trial, a quick and speedy trial. There are mandates on that. There's limitations. And it's impossible to violate one one constitutional right without violating another, just as well as it is with the rules and the codes. Okay, so you really got to get into this. Whoever under the color of law, statute, ordinance, regulation, or custom willfully subjects any person to state territory. Okay, so this tells you more what they shouldn't be doing, what they should be doing, but they aren't.
Why won't you answer me? Hello? This is your son.
Okay. They did a little bit there. People have often ask about quick and speedy trial. Okay. The presumptive speedy trial time limits person held pretrial detention should be 90 days from the date of defendant's first appearance in court after the filing of a charging instrument. How often does that happen? It doesn't, okay? Really doesn't. Okay, quite a few states have removed important Rule 3.8. I mentioned that earlier. Okay, I'm running out of time. Okay, this is